Hey guys, it's Baltimore Lauren. I'm at AwesomeCon 2017. I'm here with Sergi. Tell us a little bit about what you do.
Hi, how you doing? Well, I'm a comic book creator. I'm a writer, but I'm also the author of a book called Comic Book Law, which is basically, it traces the history of comics from a legal perspective. So it's like the ownership dispute with Superman's in it. It's also, well, actually, let me tell you the story behind it, and maybe it makes sense. As a comic book creator, I go to a lot of shows. And as a person who is a lawyer, I have a lot of friends who are comic book creators, and I have a lot of friends who like free legal advice. So a lot of friends who wanted free legal advice would come to me at said comic book shows and say, "Hey Joe, I've got this contract dispute." And I'd say, well, because of my day job, where I work as an unnamed government official, I can't really give you legal advice, but your story is very similar to what happened to Kirby in the Captain America, Simon and Kirby in the Captain America lawsuit. Or, hey, this is very similar to what happened with Archie in with Josie and the Pussycats. And so I would constantly be by this publisher who would hear me tell these stories and said, "Oh my God, this is the book and you have to write it." And at the time we had just finished a book called Great Zombies in History, so they took our zombie book and then I wrote them a legal book called The Law for Comic Book Creators. And it's been out, and so what the book is it's separated into two basic parts. There's the primer chapters that give, like, if you were a creator and you wanted to know, oh my God, what do I need to know for a contract? What do I need to know for censorship? What do I need to know for intellectual property, trademark? You could just read those chapters. But if you were like a comic book fan and you didn't care about any of that, you could just read the story of the Kirby lawsuit, and it tells you how they created Captain America and how Kirby and Simon and Kirby both think they created the Red Skull for different reasons, or how the poor Gary Friedrich and how when he created Ghost Rider and all the stories behind that and how credits worked, and Josie and the Pussycats and Howard the Duck and all those movies. So they don't even have to be good movies. They just have to be movies for people to sue about. Now I will tell you that it's used in law schools and colleges where they teach entertainment law and things like that. And every time I talk to a lawyer, they go, "Oh my God, I love the history parts. Why did you even bother to put those primer chapters in?" And every time I talk to a comic book creator, they go, "Oh my God, I love the primer chapters. Why did you bother to put those history books in?" So, I've yet to find somebody that likes them all.
That's pretty awesome.
Right.
So, to get right down to it, out of all of the weird legal cases you've seen, whether it was Josie and the Pussycats, the Seagulls, the Schusters versus DC Comics, which do you think is the most impressive or noteworthy story one?
I think the one that people don't realize, which is kind of fascinating, is, and I mentioned it earlier today on one of my panels, is you've got Shazam and Superman, right? And what happened was Superman came out, and Superman comes out as a character, and DC is very protective of him as a character. So they sue Marvel Man when he comes out, and then they sue Shazam when he comes out. Yep. And what a lot of people don't know is in the lower court of that case, right, there is a decision where the court determines that, yes, he's a copy, but he's no longer protected, because at the time under the copyright law you have to have this little notice that said like copyright or the C with a circle. The notice is not as important today, but then the notice was actually a requirement. And they found that the newspaper strips did not always have the notice, so they held that Superman was public domain.
Oh my gosh.
So in the lower court, they lost Superman. The hugest loss ever. No one ever mentions it anywhere. And then when it goes up on appeal, Judge Learned Hand, who obviously, if your name is Learned Hand, you better be a judge, otherwise you're going to get beat up, is the one who writes the opinion and decides that that no, that was a subcontractor, so it doesn't matter, and so it's okay. But I wonder how many people realize just how close we were to DC losing Superman at that time.
That would have been insane.
Yeah. The other thing people don't realize is at the time Shazam was much more popular than Superman.
He was outselling, I think, something like 4-1.
Right, and he had a movie, and he had Mary Marvel long before there was a Supergirl, and he had Captain Marvel Jr., who Elvis loved and got the rights to put on his plane. before Superboy, and he had the Savannah is arguably before Lex Luthor if you don't count the redheaded guy, but yeah.
That's crazy. So tell me more about this Josie and the Pussycats one, since Archie is my wheelhouse.
So now I forgot his name. Who created
Dan DeCarlo.
Thank you. Dan DeCarlo. Now Dan DeCarlo created Josie and the Pussycats. He created, what's her name, the redhead? She's a huge Archie fan,
Ginger.
so I'm good.
No, Ginger's not.
That's
DeCarlo,
her. She's on Riverdale, and I won't give away the plot of
Cheryl
who she
Blossom?
is. She created Cheryl Blossom, and then he also created a third character. Oh, Sabrina the Teenage Witch.
Yeah.
Okay, so he creates those three characters, and what this is kind of a lesson in law. It's called latches, and what happens is he works there. And he sits at his desk and he sees all of these things going on, like Josie and the Pussycats gets a cartoon, Hanna-Barbera cartoon, and they get underoos. Oh my God! Someday I would love to have underoos made of me. So he gets underoos, and all these things are happening. All he does is he sits and he stews. Right?
Because I don't think he's getting any kind of...
Right, he's getting nothing. And he keeps signing his checks that says, I agree, everything belongs to Archie. He signed several times an agreement that he does it. And it isn't until they, for Josie and the Pussycats, it isn't until the Josie and the Pussycat movie is going to come out that he then sues. As I said, it's Josie and the Pussycats, Howard the Duck caused a lawsuit. There's another one. Blade causes a lawsuit. All these movies, it's because, that's what I guess the important takeaway is, and I should probably have stressed this up front, is nobody is wrong in any of these cases. My book is actually dedicated to the people on both sides and the lawyers that represent them, because you got to realize that both these people, no one's wrong. There's no evil person in this. What you have is you have a company that thinks, well, I paid for these and I own them. And on the other side, you have a creator who thinks, no, well, I own it, and these guys are benefiting from my work, and both of them are working with the benefit of hindsight.
Yep.
And so that's why I do a contracts thing where I say you really need to, the best time to talk is during the honeymoon period. Because if you're not talking during the honeymoon period and you're not talking about the breakup during the honeymoon period, when the breakup occurs, it's all he said, she said, or I guess she said, he said, just to be fair. And so that seems to be what happened here, and so the lawsuit actually lasts him, and his wife is substituted in, and ultimately what the court found is, you never said anything, dude.
Yeah.
You sat on your rights. Why did you sit on your rights? And there's a lot of ups and downs, and I don't even cover it in my book. There's a lot of negative things thrown back and forth. It's the same thing with the Superman lawsuit, ultimately. There's some negativity, and people get really down in the mud, but really they're all coming from very good intentions.
Yeah. Because I know when that whole Siegel and Schuster thing with DC, if I recall correctly, they went off to war. They did. And that's when DC took over and kind of pushed them out of the picture.
Right. And that's the irony, as I said just during my panel, is if you think about it, World War II, a lot of the creators were going off to fight. Stan Lee went off, Jack Kirby went off, a bunch of people went off to fight in war because their heroes were doing it and they believed they should be doing it because that was the right thing. But what they were doing is they were leaving the publishers back in the US, and the publishers still needed to get their books out. Yep. So the publishers were hiring different people to write the same characters that these people wrote, and the audience for the most part didn't notice.
Yeah.
And so it's the creation of the corporate comic, the licensed comic, the licensed property. And back then, and after comics started to die down and we get down to the big two of Marvel and DC, it's essentially that's their stable. And when I was a kid, I couldn't tell you who were the writer and who was the artist. Yeah. I think it wasn't until John Byrne that I actually figured out who the artist was.
A lot of them went uncredited.
Right, and a lot of them went uncredited.
It was just a bullpen, so they would just pull from whoever was there. My pal Joe Gella, he was just a bullpen guy,
right.
And he didn't get a lot of credit in a lot of different things.
But if you think about it, that was the time, because who makes a Walt Disney cartoon? It's a Walt Disney cartoon. And nobody ever thought, oh my God, I'm up iWorks. I'm suing you, Walt Disney, because I drew Mickey Mouse. It just was understood that he worked for the studio and he made Mickey Mouse. It was a different time than it is today.
It definitely is. So do you have any advice for any up-and-coming creators for legal matters?
Well, let me. I guess it's not the safest thing that I tell everyone is just to make sure everything's in writing. I have a panel later today on intellectual property where I talk at a 10,000 foot level, and I mention that, and I also do video game thing tomorrow, and it's the same rule with a different result. if you are co-collaborating on a comic and you don't have something in writing, like let's say you want to hire somebody to, it's your dream, you write your script and you want an artist and you want to pay that artist to draw your characters, and then you want to put it out as a comic book and you own it and you can make the pinball machine in the movie theater, and well, that's called work for hire. Well, the only way to have work for hire is with a written instrument that says it's work for hire, or if you buy it from him, if he transfers you the ownership. So in the comics world, what happens is you're considered to be joint owners of the work, which means that you both have the right to give a non-exclusive license. So let's just say theoretically you make, I don't know, My Little Pony. And you and I make it together. You draw it, I write it, and I say, "Oh, this is great! It's a children's book. I want to license it to the Children's Network." And you're like, "No, I'm gonna give it to EquestrianLover.com, and they have the right to make stories." Well, guess what? That's kind of counterintuitive. Similarly, we would both have the right equally to make derivative works off of it, and and we would both share in any profit that were to come later. And that came out a lot in the Spawn lawsuit with Angela, where now Angela's at Marvel ultimately because Gaiman sued McFarlane over it. And so that would be my first tip. On the video game side, it's even somehow worse because it's not considered a joint ownership. But like if you say to somebody, "Hey, I want you to do these character designs for my game, and then I'll use your drawings and I'll put them in my game." Well, I've just paid a license fee to use your art in my game, and it's a non-exclusive terminable license, which means the guy can go, "Oh, your game's coming out tomorrow? Well, you can't use my character unless you give me more money." Cool. And surprisingly, it happens. Then again, there are these people in California who stand out with bullhorns on movie sets, so they'll be paid to go away. The world's full of all kinds of people. So my advice is get it in writing, and that's, make sure you know what you're in writing. And I'll also tell you, the other reason to get it in writing is a lot of times when you finally put it in writing, you realize, oh my God, we really didn't have an agreement. He was writing 5 pages and I needed 50, So.
Okay. Well, thank you guys. I'll be back with more coverage at AwesomeCon 2017. Bye.